irrevocable trust can't be changed? Recently, the Murdoch family resolved one of the biggest succession fights in recent memory, a courtroom battle over who would control Rupert Murdoch's vast media empire. And the twist? It all came down to an irrevocable trust, a trust that was supposed to be untouchable. If billionaires with entire legal teams can get trapped in a battle like this, what does that mean for the rest of us? I'm Rosanna Savone, the founder of Pinnacle Law, the legal beacon for your business and legacy. In the next few minutes, you'll learn why Rupert's trust ended up in court, what an irrevocable trust really is, and why it's so expensive to get right, why Nevada has become a magnet for the ultra wealthy, and 3 powerful steps you can take to protect your own family and business. Let's start with the story. Rupert Murdoch built his empire and placed it in a Nevada trust. The plan was that his 4 oldest children would share equal voting rights after his death. But as time went on, Rupert had a change of heart. He decided that his son Lachlan should take over alone, and he didn't want to risk the other 3 banding together to get rid of his chosen successor. The problem? The trust that controlled the empire was irrevocable. Even though it included the business he built, Rupert couldn't just rewrite the rules, but he tried anyway. His other children objected. In late 2024, a Nevada probate court stepped in. The judge ruled Rupert's move was made in bad faith, calling it a carefully crafted charade. That froze the attempt and forced the family into negotiations, and recently they struck a deal. Lachlan keeps control of Fox and News Corp through 2050, while his siblings walk away with about $1.1 billion each. It ended in settlement, but only after millions in legal fees and a very public fight. An irrevocable trust is a legal structure where you give up control of your assets permanently. That's what makes it powerful. Because once it's out of your hands, creditors usually can't touch it, the IRS often can't count it in your taxable estate, and your beneficiaries know exactly how assets will be handled. But here's the catch. These trusts are incredibly expensive to create. They often cost between $20,000 and $200,000 or more. Why so much? Because you're not just filling out documents. You're engineering an entire legal and tax ecosystem. The trust has to line up with federal estate and generation skipping transfer tax rules. It has to comply with state laws in places like Nevada or Delaware that make these trusts work. The asset protection language has to hold up against creditor challenges and fraudulent transfer laws. And if the trust owns a business, you're layering in governance rules, voting rights, and trustee succession. It's like building a custom skyscraper, not a single family home. The details aren't just details, they're the foundation. And that's why the ultra wealthy pay 6 figures to get it right. Now, here's the good news. Most families don't need to spend that kind of money on an irrevocable trust for themselves. Instead, I create irrevocable protection for their beneficiaries through lifetime asset protection trusts. When you pass away, instead of leaving assets outright, your heirs inherit through their own irrevocable trusts. That inheritance is shielded from divorce, lawsuits, creditors, even poor financial decisions, while still available for their health, education, and housing. It's the same kind of protection the Murdochs fought over, but far more affordable and practical for most families. So why did Rupert set up his trust in Nevada instead of California? Because Nevada has some of the most favorable trust laws in the country. Let me break it down. Nevada has no state income tax on trust income. California taxes trust income up to 13.3%. Nevada trusts can last up to 365 years. California caps most trusts at around 90 years. Nevada courts often seal trust cases. California probate and trust disputes are almost always public. Nevada has strong decanting laws and trust protector statutes, which let trustees adapt or move assets into new trusts. California allows some changes, but with tighter restrictions. And here's one of the biggest draws: clawback rules. In California, creditors can chase assets you moved into a trust for up to 4 years, sometimes longer. In Nevada, that window is often just 2 years. And in some cases, only 6 months if you properly disclose the transfer. That means assets in a Nevada trust can become protected much faster. So if you're ultra wealthy, choosing Nevada can save millions in taxes, increases privacy, and shortens the risk window for creditors. So while Nevada gave Rupert every advantage, tax savings, privacy, strong protections, none of that could prevent what really drove the fight: family dynamics. Rupert had a change of heart. He wanted Lachlan to take over, and his other children didn't agree. That's why this case exploded. It wasn't just about statutes or tax law. It was about siblings, power, and a father trying to rewrite the future of his empire. And it's not just billionaires. I once worked with a California family who placed their business in an irrevocable trust. When the founder became incapacitated, there was no plan for new leadership. No trust protector, no succession strategy. The result? Decisions froze, employees left, and the business nearly collapsed. The very tool that was supposed to protect the company ended up putting it at risk. And I've seen the flip side too. A mentor of mine had a lifetime asset protection trust set up for her by her grandmother with only $15,000 placed in it. She used that money to start a business. Years later, when she went through personal bankruptcy, creditors couldn't touch the business. That company is now worth more than $15 million. That's the kind of protection families really care about. So what can you do to avoid the Murdoch problem in your own planning? Number 1, add a trust protector, a neutral person who could step in and approve targeted adjustments. Number 2, build in decanting authority. That gives your trustee a way to move assets into a new trust with updated terms without going to court. Number 3, require dispute resolution. Mediation or voting procedures can stop conflicts from exploding into full-blown litigation. These simple moves don't just protect your assets, they protect your family relationships. Irrevocable doesn't mean unchangeable, but it does mean rigid. And when life changes, that rigidity can send families straight into court. That's what happened to Rupert Murdoch. Even with one of the most carefully designed trusts in Nevada, the rules were too strict to bend, and the result was a billion-dollar family fight. Your family deserves better. And here's something I see too often. Some lawyers don't spend much time beyond asking for a list of names for successor trustees, but that shortcut ignores family dynamics. Every family has its own personalities, tensions, and pressure points. If those aren't taken into account, the trust itself can become a source of conflict. When your lawyer takes the time to really understand those relationships, they can build in guardrails that protect not just wealth, but family harmony. If you're a California resident, the first step is simple: a 15-minute call with me. It's a chance to see if I can even help you and to give you clarity on your next step. Because protecting wealth is important, but protecting relationships is priceless.